Welcome, everyone. We are here for the CLE presented by North Suburban Bar and Honorable Joel Chupack, Mortgage Foreclosures in the Age of COVID. We have some opening slides we'd like to go through with you. Keep in mind your microphone will be muted. If you have a question for the panelists, there is a Q&A feature at the bottom. It's the one alongside the chat box. If you'd like to write a general message, that is the one that's used for the chat box. Pursuant to the MCLE rules, you need to be logged in the entire session, and you each have a unique login. At the end, we would appreciate it, and you will appreciate it, if you complete an evaluation form that helps us all, and that also allows you to get CLE credit for this. Please allow 3 to 4 weeks for processing of the CLE certificate. The program info is found on there. If you can write it down, I'd appreciate it rather than having me read the entire thing out. But all the materials can be located there, and each presentation will be followed by the Q&A. The North Suburban Bar Association does provide assistance, and if you have any technical difficulty, Tricia or Shelby are located at that phone number that is located at the bottom of the screen. And hopefully you won't have that kind of an issue, but they are very, very helpful and will be able to help you through getting whatever your issues happen to be. Perfect. At this point, I'd like to introduce Joel Chupack. He's a judge with the Circuit Court of Cook County. He is currently serving in Chancery Court, previously served in Eviction Court. One of the things that he handles very much now is foreclosures. He has practiced for over 30 years. He can correct me for the exact number, unless you want to keep your age secret. And during that time, he did primarily litigation, civil matters all over the board, particularly condo matters, homeowner association matters, and a myriad of others. At this point, I'd like to introduce Honorable Joel Chupack.
Thank you, Bob. Good afternoon, everyone. Hope you're doing well and feeling well. I want to thank the North Suburban Bar Association for giving me this opportunity to speak to you. And before I begin the presentation, I'd like to congratulate Judge Pat Hennigan for a good year and his leadership during the pandemic. And I wish the best of luck to Judge Megan Goldish for her upcoming year. And I feel that she's going to do a wonderful job. This is the first time in 7 months I'm wearing a sport coat, so I'd like to thank the NSBA for giving me the opportunity to do that. Let me pull up my screen here. And there we go. Okay. With me this afternoon is my law clerk, Emily Dennins. She's a law clerk for Calendar 57. She's a wonderful resource. If you have any questions, our email address is the MFML. Well, we'll get to the email addresses for all the judges in an upcoming slide, so you don't have to take it down now. Okay, so we've been dealing with this situation now for over 7 months. March 18th was the first day that the courts were closed. We are now October 28th, and there's been a number of adjustments along the way that we're going to discuss some of them. Now, this presentation I'm breaking up into 2 parts. The first part is going to be government action and court response to the pandemic. And the second part will go more in depth with the CARES Act, which is the major act dealing on a federal level, dealing with this crisis that we have. So here's some headlines that I plucked from the news, and it's interesting. Each one of these will tell you something about what we're dealing with. Because the big issue is what are foreclosures going to look like over the next year or two? So here, this top headline: Chicago housing market among most at risk to foreclosure. Not great. The next one: COVID-19 mortgage bailouts declined slightly, but a new foreclosure crisis could be brewing. At the time that this was issued back on September 11th, it was the highest level more than 90 days. There's actually, I checked on this recently, it actually defaults have fell in September for the first time since the pandemic hit. So maybe that's some positive news. Back in June, the amount there was 8.9% of all mortgages were in default. So that's pretty astounding. Next one is why the coming foreclosure crisis will be nothing like the last one. We're going to talk about that a little bit more on the next slide. And this last one is something I had to give some thought about, that the type of recovery we had back in the last meltdown, which is 2006, 2008, was a V-shaped recovery. The prices dropped tremendously on real estate, then they went and they went back up. That's what they meant by V-shaped recovery. What a lot of the people writing about this are saying it's going to be a K-shaped recovery. What that means is the top half of the K is really for the affluent people. Going to go down a little bit, go up. The bottom half are for the people who really suffered last time around, and they're going to suffer again. And these are the people that really don't have equity in their homes. I'm talking about the essential workers, lower wage employees. And also there's doing some research for this presentation. There seems to be a knowledge gap as far as what borrowers can do to protect themselves. There is the CARES Act, there are other resources as well, and the word has to get out that these are available, otherwise they're going to fall in the bottom half of the K. So this is a chart that was from the Chancery Division, and it shows the foreclosure activity since this has been monitored. You take a look at 2003 and 2019, you have about the same number of foreclosure cases pending in those years. Think about the foreclosure activity as a long snake, and somewhere around 2006, 2007, that snake ate a giant fat rat, and it just ballooned up. At one point, and you can see 2012, I have highlighted because that was the top point for the number of cases. That 78,000 plus came out to about 8,000 per calendar in foreclosures. It was just mind-boggling. And then you could see a decrease. So the big question is, what's going to happen after the year 2020? No doubt there's going to be another rat that the foreclosure is going to be eating. It probably won't be as big, and we're going to talk a little bit more about what that might look like and what are the reasons why it may not be as bad as last time. So there's been numerous governmental actions and court actions in response to both the health crisis and the economic crisis caused by the pandemic. The CARES Act we'll discuss towards the end of the program. And this is just a list of the type of actions that have been taken that we're going to get to in further slides. So let's start with the governor's disaster proclamation back on April 23rd. He set an eviction moratorium. It does not directly affect mortgage foreclosures, but they kind of go hand in hand because in both situations, you can't dispossess somebody from their residence, and this will end up causing more of a health crisis by doing so. So that's the reason for the governor's disaster proclamation. As you may know, he's been enacting a new proclamation every 30 days. There's litigation about it, but as of now, the latest proclamation entered on October 16th, extended it through November 14th. we'll see what happens, but my guess is if nothing changes on the ground, nothing's going to change as far as this goes, unless a court comes in and stops Governor Pritzker from furthering issuing executive orders based on an emergency. The Illinois Supreme Court has also issued a number of orders in respect to this crisis. These don't directly affect foreclosures. The 298 petitions now have to be submitted online. You cannot go to court and have it issued. The individual judges, calendar judges, are hearing the 298 petitions. It used to be that there was one judge that would hear them. So if a self-represented litigant will be filing a 298 petition, I will be the one to be reviewing that petition and granting it. It is also important to note that the form of the summons have changed as a result of the pandemic, basically to let the defendants know that matters will be heard virtually. So make sure you use the proper summons form. The Supreme Court of Illinois has an excellent website, by the way, for anything dealing with the pandemic. They have videos you can see, how to Zoom, all the protocols for remote court proceedings. And I just found this interesting when I was going through it. I guess they're looking for a silver lining here in the pandemic, but probably things will permanently change as a result of what we're experiencing right now. There'll probably be less need for in-person hearings. So that's something that I think will stay with us. The last bullet point here, the pandemic will no doubt continue to present novel issues and challenges to the administration of justice for the foreseeable future. That's certainly correct. In fact, if any of you out there have experienced any such issues during the last 8 months, please let me know. Use the Q&A function on it and let me know things that you've encountered that you really didn't experience. We'll share it and it'll help all of us. It's certainly a challenge for self-represented litigants as well. Many times they're used to coming to court. They just either don't have the computer access to do the Zoom hearings or not. It's something that we're working through. But I did find out just the other day that CL16 is going to be opening up on a limited basis where there will be terminals there for self-represented litigants to participate in Zoom hearings at the CL16 site. And the Illinois Supreme Court has come up with a guidance document for remote court proceedings, which you may want to review for reference. Also, the Illinois Supreme Court has promulgated 2 new rules in response to the pandemic. The first rule, 45, just allows hearings to be conducted by either telephone or video conference. That was not an option before. And Rule 241 is similar to 45, but that deals with evidentiary hearings or trials where testimony can be taken via Zoom. So Chief Judge Evans has issued numerous general administrative orders dealing with the pandemic. This one deals with the sheriff. The last one that was entered on October 16th, the sheriff cannot enforce any residential orders of eviction until further order of court. Before, it was on basically a month-to-month basis. Now for the near future, there's going to be no residential evictions. That would include an eviction resulting from a foreclosure. Okay, this is also from the General Administrative Order. You could just read this on your own. The reason why I put it up here is what have we been doing over in Chancery in the foreclosure section for the last 7 months? We've basically engaged in what is called triage. We've been trying to deal with the cases that we can deal with. We basically have a 7-month and growing backlog of judgments and orders confirming sale. So we've been making some determinations, what we can hear, what we can't hear, and this is the authority for the court being able to do that. The purpose of the triage is to reduce the need for counsel and parties to appear in court, even virtually. Now, at this point in time, most of the calendars, if not all the calendars in the mortgage foreclosure section, have instituted virtual court hearings. So you would, instead of coming to the courthouse, you would just log in with a dedicated Zoom login for each of the calendars at the regularly scheduled routine motion call or contested motion call. And again, this was taken from the last GAO issued by Judge Evans. And here it says that all mortgage foreclosure judgments, evictions, and furtherance of a foreclosure and foreclosure sales are continued until further order of court. So no more month-to-month waiting. It's been one of the issues we've experienced over the last 7 months. A lot of the plaintiff practitioners would continue their cases until after the expiration of the last order, only to find out that it's been extended. So now the guesswork is out of it. Unfortunately, we're headed into a very difficult period in the fall where it doesn't seem like the pandemic is going to be lifting anytime soon. So this is the new normal. No foreclosure judgments, no sale approvals, no evictions. In addition to the GAO issued by Judge Evans, Judge Jacobius, the Chancery Division presiding judge has issued his GAO. This GAO clarifies that the mortgage foreclosure moratorium applies to both residential and commercial foreclosures. And again, this is extended till further order of court. And by the way, I provided the North Suburban Bar Association with additional materials, and in that is the Chancery Division GAO 2020-11 and 2020-12. Okay, again, no sales can occur, no scheduling sales can occur, and if a sales had been scheduled, it's just going to have to be renoticed and republished. All right, so let's talk a little bit about what the court cannot enter. No judgments of foreclosure, no summary judgments of foreclosure, no orders of default, no orders approving sale, no orders for possession that would displace a resident or a tenant. Even an order for special process server will not be entered unless there's exigent circumstances. And the last bullet point is a little bit, gives the court some discretion, and the judges in the mortgage foreclosure section will interpret this last one differently. Any other order the court determines being furtherance of a foreclosure, sale, or eviction. So there's some wiggle room there. Some judges take a more restrictive view. I do not, but some judges put more things on hold. Okay, what can the court hear? Well, withdrawal of motions, that certainly makes sense. Voluntary dismissals, that makes sense as well. In fact, there's been a lot of voluntary dismissals because there's an infrastructure in place to deal with loan workouts. So there are a number of default mortgages that are being worked out, which is what is quite different from what happened back at the last mortgage meltdown, where there was no system in place to really modify mortgages. Now there is, and it's working. So we're seeing a lot of dismissals. If you have a vacant property, you can file a motion with the court to have the matter proceed. You have to provide proof that the property is vacant or abandoned. That proof should be in the form of an affidavit from a property manager. It should be perhaps pictures attached to it. Sometimes you're able to get a statement from a neighbor. Sometimes you're able to verify whether or not utilities have been shut off. But whatever you can do to show the court that the property has been vacant or abandoned, you should attach as an exhibit to the affidavit or the motion. We will hear petitions to appoint receivers. In fact, we've seen a number of them. As you can imagine, there's a lot of strip centers, shopping centers, office buildings, other commercial buildings where tenants have just not been able to pay enough rent for the owners to pay the mortgages. So we're seeing a lot of receivers. It's a lot of receiver action happening right now. No sale approvals. There is an exception if the sale occurred prior to the shutdown of the courts and there was a third party that was a successful bidder, then you can proceed. I've entered a few of these, but now we're 7 months into it, so most of those have already worked their way through the system. We could also hear cases to appoint special representatives. You need a special representative where the mortgagor is deceased or has become deceased since the court was filed. You will need to have a special representative to take the place of the deceased party. Case management conferences, we are hearing those. The 4331 order is, no further case management is necessary. If a mortgagor or the mortgagors have not been served, we will give it a new date. I usually look at a date about 4 months down, and we'll bring it back then to see whether or not the plaintiff was successful in getting service. If in fact the mortgagor does appear at the case management conference via Zoom, we will request that they file their appearance and answer within 35 days. The other change in the Chancery Division GAO 2020-11 is there's now a Zoom hearing protocol. If you practice in the Chancery Division, please read thoroughly that GAO. It is important to make sure that you know the remote hearing protocol, because if your notice of motion does not have the appropriate language in it, and if you do not include the Zoom instructions in English and Spanish, your motion may be stricken. You have to comply with this GAO. One second, I think, I missed one here. Okay. Going back to matters that may be heard by the court, we will hear emergency motions. I have not seen a legitimate emergency motion in the last 7 months. The closest that really have come is really petitions to appoint receivers where somebody needs to get in right away to protect property, but we can't hear emergency motions. We could certainly hear continuance of motions. And we could also enter consent judgments and agreed orders. That's certainly permitted. We will also hear contested motions as long as it's not a motion that will end up in a judgment of foreclosure. There's still litigation going on motions to dismiss complaints, affirmative defenses, and counterclaims. That is very active. We are hearing those cases. Discovery motions as well. We can certainly deal with that. Now, you're going to be communicating to the court all through email, and for Chancery, for the mortgage foreclosure mechanics lien section, this is the email address that you're going to use. Just insert the calendar number after ML calendar. Just insert it at cookcountyil.gov. In my case, it's calendar 57. My law clerk, Emily, checks the email on a regular basis. We try to get back to you as soon as possible with any questions or any responses that we have to what you've submitted. So make sure you have that handy. Okay, we discussed remote hearing protocol. And for those of you who practice in federal court, they also have their own standing orders. The most recent one is extended November 16th. The only major change here is in the beginning part of the pandemic, they weren't allowing delivering of courtesy copies and in-person presentation of motions. Those have been relaxed, but certainly check their website to make sure you have the most current order. Okay, I'm going to take a little break here and just ask Bob if there's any questions that parties have on the first part of the presentation. We could take that up now.
There are a couple of questions. One is a more general one, and that is because there's a moratorium on both commercial and residential, do you anticipate lifting one before the other? The commercial before the residential?
You know, that's a very good question. To date, they've been treated in tandem. So I'm just going to stick with that. I think they will be considered together. I don't think it's at this point yet, they're going to be separated.
Also, when cases are brought before you, obviously there's going to be a great deal of documentary evidence. How is evidence, documentary or otherwise, if it's non-testimonial, supposed to be presented? How do you do it in your courtroom? And have you heard about how they're introduced in other courtrooms?
Can you read that first part of the question again?
Oh, I'll do my best. Obviously, testimony is going to be done you can do that through Zoom without other issues. When you have documentary, photographic, or other evidence that needs to be presented, how is that being handled in your courtroom? And have you heard how it may have been presented in other courtrooms?
Okay. In mortgage foreclosures, the only type of evidentiary hearing that we have had has really dealt with motions to quash service. And in those instances, we do request that the witnesses, whether it's special process server and any rebuttal witnesses, they do appear via Zoom, and we do take their testimony, and we have done that. Most of the other matters that our section deals with is really on documents. So if you're presenting any sort of motion and an affidavit, you just include all the documents attached to the affidavit or the motion, whether it's for judgment, if it could be entered, shorten the redemption period, anything else, you just provide it. We do need the PDF file to be tabbed because, you know, we'll get an attachment with 400 pages to it, and it's very hard to navigate through it. So you have to break up your submission with a tab PDF file so we could easily jump from one section to another. So I hope that answers that question.
You mentioned earlier that you haven't had any emergency hearings yet. Are there any particular areas such as spoliation or anything else that you can think of that would qualify as an emergency so people can, depletion of one form or another, so people would get an emergency before you?
Well, I have not seen any like spoliation of evidence issues come before me. I mean, certainly if any party feels that that could happen, or if they feel there's some sort of emergency, I don't want to discourage them from coming. It's just, in reality, the type of emergencies that this section has dealt with in the past has been where there's a sale pending and the borrower has some reason to try to delay the sale. They either have a purchaser for the property or a refinance or something. That's been the majority of the emergencies that the mortgage foreclosure section has seen. Other than that, it's really just, a case-by-case basis. And again, like I said, it's really, really receivers coming in needing to take over the property as soon as possible is really the closest that we've got.
Have you received any motions for mediation of cases?
We have not.
Is that something that you would receive?
At this point, unlike the mediation program that the mortgage foreclosure section had terminated back in 2018 as the meltdown crisis was over. It may pick up again, we don't know. But that question is good in that there are a number of options that borrowers have that the servicers know about. So there's less of a need for the court to really engage in the mediation because it's being done as part of this whole CARES Act.
The form that you presented earlier showing the number of foreclosure cases being filed, I think since the early 2000s, is that something that you would be able to send to the NSBA so that we could forward it on to anybody who wanted to look at it?
Yes, what I will. It's actually a more comprehensive document. It's a one-page document that has other charts on it. It's just something I couldn't get on the PowerPoint, but I will send that to the NSBA. It also has a list of monthly filings and has some nice charts there as well. So I will go ahead and send it to the NSBA if you want to get it out to anybody who's participating. That's fine.
Those are all the questions I think we have. Does anybody else has any for the Q&A? See if there's anything that's come in. I think you're up to date.
Okay. Before I move on to the coronavirus, one of the, we've all had to adjust working remotely. I don't know if you noticed my virtual screen back here. I just want you to know I'm not being held hostage anywhere, but this is my screen. As long as Toto, my dog, doesn't pull the curtain down, I'll be okay. But everybody's got their own way of doing it, and I feel it's better just to have a blank background so parties are not distracted. So we're moving on to the CARES Act. And the CARES Act is the largest emergency aid package in US history. $2 billion has gone into this to fight the spread of the COVID-19 disease and to prevent the US economy from collapsing. And the mortgage the mortgage relief is part of it, but this is just an amazingly immense document that tries to really address the situation. Whether it's been successful, we don't know yet. There is right now, as we speak, about 6.8% of mortgages are in some sort of COVID-19 forbearance pursuant to the CARES Act. that, give you an idea, that's about 90% higher than the number of foreclosures you would normally have. So you've got a tremendous amount that we're dealing with right now. Excuse me, I think it was in June, 8.9 of all mortgages were in forbearance. As of September, 6.8% of all residential mortgages out there were in a COVID-19 forbearance. There's actually a blog called the McDash Forbearance Tracker, where you could get information about the number of foreclosures on a national level that have been filed, how many are in forbearance, and all that. It's produced by a company called Black Knight Inc., which is a data company, and it's McDash Forbearance Tracker. So this is what the regulatory agencies have done to deal with the pandemic. Fannie Mae has a suspension of all foreclosures and evictions. It was to expire August 31st. It's now through December 31st. We don't know if it's going to be extended beyond that. In addition to Fannie Mae, it doesn't say it here on the screen, but the other housing agencies have followed suit. Freddie Mac, VA, FHA. All of them have moratoriums on foreclosures until December 31st. And as you can see on the bottom, at least 2/3 of all homeowners have a loan that is somehow supported by these entities. Now, for any houses, any mortgages that are not covered by this suspension are still covered by preside or Chief Judge Evans moratorium. So even if you have a residential mortgage that doesn't qualify or is not part of a Fannie Mae or government-backed mortgage, there still is a moratorium on it. Okay, and these are the pertinent sections of the CARES Act. We're going to be spending time on the first section, 4022, not too much on the second, and nothing on the third, since that deals with evictions, but you should be there. You should be aware that it's there. And these next 3 pages, it's just there for your own knowledge. I'm not going to go through it directly, but we'll talk about it. Second. Okay, so that's just the statute. The CARES Act provides 2 types of relief. One, there's a moratorium through December 31st, and there's a forbearance provision as well. I would like to explain the moratorium is actually through December 31st, or when the president declares that the pandemic is over. So theoretically, President Trump, at any point in time, can declare the pandemic over, and then this type of relief would end. If the president does not do that, then no foreclosure can be initiated or executed through December 31st. Now, the borrower can request and obtain from the servicer forbearance for 180 days. And once that expires, they can request an additional 180 days. So basically, a borrower has a year to try to get back on their feet. These are the type of loans that are subject to the foreclosure moratorium. And what is a federally backed mortgage? those that are insured or guaranteed by the FHA or the VA or Fannie Mae or Freddie Mac. This number is a little different than the 70%. This source said that approximately 62% of all residential mortgages are federally backed. And if you do not have a federally backed mortgage loan, if you do not know you have it, there are a lot of ways to find out. I'm going to get to some of them, but you might want to check your lender's or servicer's website. Excuse me, if you don't have a federally backed mortgage loan, there are still options there. So check your lenders and servicers website to see what they're providing. There we go. So if you don't know what type of loan you have, here are a couple places you can find out. Or you could ask your servicer. What about reverse mortgages? They are, it says they're practically all of them are FHA insured. So they would qualify for a moratorium as well. Okay, how do you qualify for forbearance? You need to make a request to your servicer. So as you counsel your clients, make sure that one, it's the servicer that the request be sent to. The Act doesn't state whether it has to be in writing, though it should be in writing, but theoretically can also be oral. But also make sure if the property is already in foreclosure that you send that request to plaintiff's counsel so they know that they need to put a hold on the foreclosure action. Now, all you have to say is that you're experiencing financial hardship caused by the COVID-19 emergency. There is no need to provide documentation. There's no interview. There's no affidavit. You just have to experience direct or indirect financial hardship from the COVID-19 emergency. That last bullet point is a question that has not been addressed yet. Can an heir of a deceased borrower request forbearance? There is some thought out there that they can, that under some regulatory language, they are deemed a borrower. But certainly if you're in a situation where the borrower has passed away, but you're still living there and you're the heir of the deceased borrower, you should still go ahead and request forbearance. Okay, we talked a little bit about it before. Okay, this is the covered period. It began on March 27th. It'll end on December 31st or earlier if the emergency has terminated. And also, even if the loan's already in default and even if foreclosure has commenced, the borrower still has the right to request forbearance. Okay. So what does forbearance get you? What happens at the end of the forbearance period? Okay. Well, first, during the forbearance, there's no fees, penalties, or interest. That's in the CARES Act. So you don't have to pay any of that. But it's not forgiveness. You still owe the money. Question is, what's going to happen? And there are different workouts available depending on the type of loans. These are just some of them, but you've got to check with your servicer to see. A reinstatement would be that you're able to bring a current and you have a certain amount of time to bring a current. Sometimes they'll extend the payment period if, they'll just tack on another 12 months if you were forbeared for 12 months. But there are special options out there and you need to talk to your servicer about it. One thing to be aware of is even if you don't pay your principal and interest, you're still going to have taxes and insurance that you're going to have to pay. So, when you ask for forbearance, it's only on the loan amount. You know, you're still going to have to keep current with real estate taxes and payment of your homeowner's insurance. If you do so, you're going to get a better workout option than if you don't. One thing that we don't know about yet, and this is something that we'll see when this plays out, is can this be raised as a defense in a mortgage foreclosure action, whether or not the lender followed the CARES Act, if they were requested and they weren't given, whatever. This is not just a hypothetical situation. Anecdotally, in the research that I've done, there's been a number of instances, mostly among Black American communities, where they have not been told what their options are, and they have proceeded with I got jumped ahead of myself. They've proceeded with foreclosure actions or whatever. So just having a little problem here. Okay. All right. Okay, you could also, if you have a property with 5 or more units, there's the CARES Act also addresses that as well, if it's residential property. These next 3 slides I'm not going to go through. This is just the statute verbatim, but it's there for your reference. And here, if you had to have been current as of February 1st, and then you could submit an oral written request for forbearance, and it will give you a 30-day forbearance, and you could renew it for another 30 days. And the important thing to remember here is if you do take advantage of that, you cannot proceed with evictions on a filed case. Most of these have already been worked through, so I have not encountered this. But it's something you should be aware of if you represent a tenant in a foreclosed property and it's 5 or more units. You may want to find out whether or not your landlord has taken advantage of the CARES Act protection. If they did, they are barred from proceeding with the eviction.
We had a few questions. Would it be okay to take some now before you go on?
Yeah, I'm near the end. We could go ahead and take it now.
Okay. Are there any penalties you would levy against a lender for violating the moratorium?
There are, and I think they're pretty, I don't have it at my fingertips, but I came across it. There are definite penalties. I just wasn't part of my presentation, so I don't know what they are.
Okay. With regard to auctions sales, has there been any discussion or movement as far as moving the auctions to being an online basis?
Not that I'm aware of. I mean, I have seen some of the orders for sale to include an online presence. But right now, since we can't even conduct sales anyway, I don't really have a good answer to that. I mean, we just can't do sales now, regardless if they're virtual or not virtual.
Does the law provide any extra protections for essential workers versus non-essential workers as borrowers?
No.
Okay. Did you mention, you may have mentioned something before about a balloon payment option in a forbearance?
Yeah, well, that's the reinstatement option. I mean, certainly if you decided to exercise your right of forbearance and you did it for 180 days or 360 days, at the expiration of that period, you could go ahead and just pay that amount without any penalty, without any interest. and basically reinstate your loan.
To your knowledge, does the violation of the moratorium, I know you mentioned that there might be some penalties or sanctions involved. To your knowledge, would it create an independent cause of action by a borrower against a lender?
If it's provided for in the in the regulations, perhaps, but it would certainly be a defense.
Normally, that's filed as an affirmative defense, if it does exist.
And I don't know. Again, this is something that we're not going to see for perhaps another year until all these forbearances work their way through the system.
Okay. All right. Sorry for the interruption.
No, not at all. I just have a couple more slides, and I'll double check to see if I left something out that I meant to say, but this is probably the most important slide of the presentation. There's some excellent resources that will probably answer some of those good questions that were just asked that I didn't have the answer to. Legal Aid Chicago, I really like their website because they have a nice one-page color-coded flow chart that I think I included in the materials to determine how the defaulted mortgage will work its way through the process. And they also have some very good Q&A there, so I really recommend that. Chicago Volunteer Legal Services, they have a really comprehensive list of links to government websites where you can maybe find out that answer to about the penalty for a servicer not complying with the CARES Act. The Lawyers Committee for Better Housing is geared more towards tenants, but again, it's a very comprehensive website. The National Fair Housing Alliance is also, I found, very useful in preparing for this presentation. And the IDFPR has also has some excellent resources as well. Now, for all of you that are homesick and you want to get back to the Daily Center, this is what you're going to see when you get back. This is actually my old courtroom in 1408, but there you have plexiglass shields to protect the clerk and the judge. You got that little speaker hole there, and actually, if you could see out to the left and the right, there's even plexiglass separating the judge from the clerk. So if you need to hand anything up to the court, everything's being handed to the opening by the clerk, and then the clerk's going to have to hand it to the judge. You see the place stickers on the mat here for where party's supposed to stand. So for those of you who have not been in the Daily Center recently and wanted to see what it's like, there you go. Okay, let me go back. Okay. Is my screen still visible? Bob?
Yes, it is.
Yeah, you might want to hit the play button though if you want to go back into the presenter.
Oh yeah, okay.
View. There you go.
Apologize.
Good to have IT help.
Yes. Okay. Any other questions up there?
I do have one. Are servicers required to review a homeowner's loan modification application?
I think you gotta, if it's a federally backed mortgage loan, then there are workout options available to them. And so for those type of loans, yes, they would have to. Your servicer would advise you the options available to you, and they would have to take your application. If it's not a federally backed loan, you should still check with them, because most lenders, private lenders, are following suit and providing some sort of workout options.
Is there something that a court can do to ensure that the servicer reviews such an application? I assume the question assumes in it, can they just, even if you make an application orally or in some form of writing, can they just either ignore it or not even bother with it?
Well, I guess I have to think about how that issue would get before the court. And I would envision it would get before a court in the mortgage foreclosure section, only if the plaintiff is pursuing the foreclosure, and this would be raised as a defense. So that's how I see it coming up before our section.
I have one question here in your capacity as a former judge handling forcibles, although I suppose it could also apply in foreclosure actions, and that is, are eviction cases being held in person? I think you kind of covered that earlier when you were talking about having Zoom information actually on the summons these days.
Yeah, only emergencies. They are doing some. They are hearing some by Zoom, but they're also, people do walk in, and sometimes they do hear them in person as well for emergency situations.
I believe those are all the questions we have.
I will say anecdotally, I have heard that there's been more lockouts as landlords get frustrated with the process. There has been some incidents of self-help where landlords have turned off utilities or otherwise have made it impossible for tenants to stay in the place. So those sorts of things are being heard by the courts. As you know, at an emergency basis. And I think there's one other thing that I wanted to make sure I covered. No, I think I got that. I think I did cover it. So no, that's all I've got.
There were a couple of other questions.
Okay.
One of them is not in your capacity as judge, but when you were practicing, what was the best way that you found to obtain information from your opponent? Was it through discovery or through motion practice?
I got to give you a lawyerly answer, and it really depends on the situation. It really depends on what I was looking for.
That sounds safe. One other is,
abstract.
As far as foreclosure cases, is discovery permitted? I'm assuming it is, because anything
Yes.
non-small claim would have discovery.
Yes, we do have discovery, and it's and like I said, we handle motions with discovery, so that still goes on. Oh, okay. This is what I wanted to just make sure that people were clear on with vacant or abandoned properties. We're seeing a lot of these. So it is an exception to the moratorium. And in addition to filing a motion to proceed under the GAO, you may also want to file a motion to shorten the redemption period under IMFL along with it. And the motion to proceed under the GAO should be a separate motion. and a separate order as well. What the court wants to see when you send the courtesy copies in, we want a copy of all the proposed orders that go along with your motion as well. And if my law clerk, Emily, is still on, if there's anything she would like to add, now's the time to do it. You can send a quick note to Bob, but she's been very helpful, and it's been really, really difficult in basically administering all these cases without being able to come to resolution. And we wonder what things are going to be like once the moratorium lifts. You know, we're going to have 9 months of cases, if it gets lifted December 31st, 9 months of cases for which no judgments were entered and no sale approvals were entered. And that's going to be really something. Oh, I remember now, I said I was going to talk about this, about how this will differ from I'll end on this, how this will differ from the last pandemic when we had that snake eating that fat rat. You know, really, it just snowballed, and there was so much subprime lending out there that it was just unbelievable. Here, it's a lot more restrictive. The market is doing pretty well, the housing market, and it seems ironic, but actually this last month, September, had the highest percentage sales in 8 years in the Chicagoland area, which includes the Collier counties. And it almost seems counterintuitive. Why would sales be so great? We're in the midst of a pandemic. Well, people have a lot of equity in their homes, for one. It's easier to sell because of that. They also are looking to live a pandemic lifestyle. Many people are fleeing the city. They do want to have a backyard. They do want to be out somewhere where they can not be confined to a 1 or 2 bedroom apartment. So that's happening. Also, mortgage rates are low, so it's easier to refinance and get yourself out of a bad situation. And I think a lot of the real bad loans are gone. You know, the underwriting guidelines have been pretty tough the last few years. So you're not going to see a lot of those really bad, no income stated loans and 100%, no equity loans, any of that. So a lot of those have gone away. And also there is, as I mentioned before, there's a pretty strong infrastructure in place among all these lenders and servicers to deal with default situations. And we're seeing it, and workouts are being done, and there are modifications being done. So I think all that is going to result in not as big of a problem, I think, as people may anticipate. It'll certainly be higher, and there'll be a tough workload in dealing with all the past foreclosures and sales that we've had to put off. But I think we'll be able to handle this. It's not going to be anywhere near the 8,000 per calendar that we had before.
We did have one final question, a very practical one. Are there any differences that you know between discovery between Law Division and Chancery?
I would say practically the difference that I see, and it's not one that's in the rules, it's just one dealing with the volume of potential documents that you could get in a mortgage foreclosure situation. I mean, there are tremendous amount. I've seen requests for tremendous amounts of material dealing with servicer guidelines and handbooks and all sorts of things that are probably not relevant. Also, when it comes to the printouts. You could have a printout of 100, 200 pages showing the activity on an account, and it would be too burdensome to really necessarily have to produce that, and they probably wouldn't even be able to interpret it. So, those are some of the issues that have come up.
We don't have any further questions. I think if that concludes the presentation, it's actually after 5 o'clock. So thank you for an extra 5 or 6 minutes of presentation. And on behalf of the North Suburban Bar, thank you, Judge Chupack. Thank you to all of the attendees. We hope you will become involved with the North Suburban Bar. We have CLEs like this one and more coming. And we also have many other, well, we're a bit limited now in our normal presentation because of COVID, which is why we have presentations such as this. But we hope that those of you who are listening to this and are not yet a member will look into becoming one.
Thank you, Bob.
Thank you for that reminder. Make sure that you fill out the evaluations. And as was said earlier, the CLE certificate should be available within about 3 or 4 weeks. If not, please contact the NSBA, who will contact me, and we'll make sure that we get those out to you. Thank you, and I guess this will conclude our presentation. Judge Chupack, thank you so much.
Welcome. Thank you for the opportunity.